Title IX investigations at universities and high schools and colleges. Reform is coming on August 14th of 2020. The United States Department of Education has been looking at revamping and working due process into these procedures because there's been so much inconsistency, especially among colleges and universities, as to what an accused person gets in terms of due process, if they get any due process at all. There's been a long public commentary and rulemaking so that the balance is fair both for complainants who are alleging that they are a victim of sexual harassment or sexual misconduct, as well as now the respondents who are saying, wait a minute, my whole future is at stake here, my future to continue on at my college or university, my ability to transfer and what's going to happen on my transcript if I want to transfer, my ability to get a job later, and many other things, my ability to play sports if you're an athlete at the university or whatnot. So these changes have been long coming after the Dear Colleague letter was issued in 2011. Finally, the regulations just came out earlier this week, and they take effect on August 14th of 2020. My name's Ryan Pacyga. I'm a lawyer, and I protect students and faculty accused of Title IX investigations and being accused of sexual misconduct or other violations of university or school rules as well. And so some of the main changes that we're going to be seeing that are going to take effect on August 14th, it's worth noting that there's nothing that stops schools from implementing these changes right now. It's just that the deadline for them to institute these changes is August 14th of 2020. And I'm going to talk mostly about allegations of sexual harassment or sexual misconduct because those are oftentimes the most devastating allegations that can be made. And as a parent, you might want to know what your child's rights are here. Number one, finally, we're going to have a presumption of innocence. You might not believe it, but before August 14th of 2020, students that are accused of sexual misconduct in many universities do not enjoy a fundamental presumption of innocence. The playing field will be leveled, and now all universities will have to honor that presumption of innocence and give that to an accused student or faculty member. Second, you have now a right to a live hearing if you're accused of this, instead of just an investigation without a hearing, but rather a live hearing, and you have a right to an advisor. Some schools have said an advisor just means another student that can sit there or a parent or whatever. Now you have a right to an advisor, and that advisor can be a lawyer, and probably should be a lawyer if the accusations are that serious. And so the school cannot keep a lawyer from now participating in these live hearings, and you have a right to have that lawyer conduct cross-examination of the accusers or any other witnesses in these live hearings. So that's a good fundamental due process change as well. Sufficient time to respond to allegations and to gather information and review the evidence. Universities have historically sped through. They take their time doing their own investigation, but then once they haul you in for the interview or they make the accusation, they give you almost no time to respond, and frankly have gotten in the way of students or their lawyers wanting to investigate this information or get their hands on the alleged evidence so we can give a fair protection to people. That's going to be changing as well. Impartial decision maker. Sometimes universities have used the same Title IX coordinator to do the investigation and then be the decision maker. You can understand how that could lead to bias. It's the same reason that courts have said that police can't be the prosecutors, because even subconsciously they have a little bit of a dog in the fight at that point. They've got their own opinions, and they wouldn't be able to neutrally evaluate the evidence as a decision maker, which is why the courts separate law enforcement from prosecutors, and now the investigator cannot be the decision maker as well. So you have a right to an independent and fair investigator and neutral investigator, as well as a neutral decision maker in this process. You have a right to receive all of the evidence in the case now, and to have someone objectively evaluate that evidence. That's important. And finally, universities, most of them that I've done cases with, they use what's called a preponderance of the evidence standard, which just means 50.01% more likely than not is all. Just a slight, it's even and then a fingernail, in other words. Just tight, small tilt of the scale there. Universities have the choice to use what's called the clear and convincing evidence standard, which provides more protection to an accused person. Frankly, I think that's the standard they should use, of course, because these allegations are so serious, and you wouldn't want to end somebody's future on just an allegation where all they need is preponderance of the evidence. Now, it also says that if the university is going to give a certain level of protection to faculty, let's say a faculty member is accused of this, and the university says, well, faculty members enjoy the higher protection of clear and convincing evidence. Now the law on August 14th is going to say universities need to provide that same level of protection to an accused student. So if the university says clear and convincing evidence standard for professors and the like, they now have to give that same level of protection to students. Universities could say, we're only going to give a preponderance of the evidence standard to professors or the like, and then they can use that same lower standard for students, but they can't give a higher protection for faculty and a lower protection for students in these cases. So that's a roundup, a very brief summary of the new changes that are coming to Title IX. If you're a parent or you're a student and you're involved in a Title IX investigation and you have questions, you want to know what your rights are, feel free to shoot me an email or get a hold of me. You can email me, Ryan@arrestedmn, like Minnesota.com. That's Ryan@arrestedmn.com. Or find me on my website or call me at 612-339-5844.